Good evening. My name is Brad Myers. As Bruce said, I'm with the King Miller Law Firm in Baton Rouge, and I'm going to very briefly describe for you what the program we have put together for is a claims resolution process for those who are not represented by a lawyer, who are not a plaintiff, are not identified as a plaintiff in a pending lawsuit, and who have contacted us and don't want a lawyer to attempt to resolve their claim. I'm going to be somewhat limited in what I can talk to you about simply because there are pending federal and state lawsuits. We are under constraints from the federal judge as well as federal law as to what we can say to people who are members of the class. And all of you, if you live within the evacuation area, are identified as a putative class member, meaning that if at some point in time the judge certifies a class, it will likely include those people who were evacuated. So because of that, I need to be very careful what I tell you and what I can talk to you about, what kinds of questions I can answer. I will tell you this, that the lawyers who are involved in the class action are very experienced lawyers. If you are represented by a lawyer, I suggest that you talk with that lawyer about your individual situation, and we're happy to discuss a possible resolution of your claim with your lawyer. Nothing I say tonight, you should not take anything I say tonight as any suggestion that you not have a lawyer, or that if you have a lawyer that you dismiss your lawyer. I know those in the federal court, and there are some of you out there who have lawyers who have contacted us to talk about resolution of your claims, even though you're not involved in a lawsuit. I know all of them. They're all very competent lawyers, and we're happy to work with them to try to resolve your claim. But there have been a number of people who have contacted the company through the command center who have indicated to us that they want to try to resolve their claims without having a lawyer involved. And that is the process that I just simply want to tell you about tonight. Beginning on Monday of this week, the Worley people from the Worley Claims Service began contacting those of you who are not represented by lawyers, who contacted us and asked us to discuss with you the possible resolution of your claim in order to set up a meeting. First, a meeting so that you can fill out the necessary forms that we need before we can proceed with the process. And secondly, to set up an appointment with you so that the appraiser and the adjusting company that we have retained to help us evaluate your individual claims can go out and inspect your property. So there will be two occasions that you will have to meet with representatives of the company. The first is to fill out certain forms. We need a form that you acknowledge that you are not represented by a lawyer, just to protect us so that we don't violate any rules that the judge has set in the federal court litigation in New Orleans. And it also is an acknowledgement that you recognize that if you want a lawyer, you can have one at any point in the process. If you want a lawyer, you can get a lawyer and have that lawyer contact us, and we will continue the discussions through your lawyer. The second form that we need you to fill out will be a claims information sheet. It is important. It's got a number of items in there, one of which relates to whether or not you believe that your property sustained actual physical damage, for example, a cracked slab, cracked windows, cracked sheetrock, that sort of thing. That's important for our purposes for the evaluation of your claim. One of the other things that we ask in this claim form, or the claim information sheet, is we ask you whether you have an idea of what you believe your claim is worth, and to please share that with us so that you can take that into account in your evaluation. For example, if you believe your claim is worth X number of dollars and we agree with that, we may want to go ahead and proceed to the resolution of that claim immediately without even inspecting your property, if that's what you want to do. The second meeting that you will have to attend is a meeting that you arrange with the Worley Claims Service people so that they can go out and inspect your house. They're going to go out and take measurements and the appraiser, because what ultimately The ultimate goal for us is to attempt to put a fair market value on your property at a time prior to the development of the sinkhole and the evacuation order. And that is the initial basis for our evaluation of each claim, the fair market value at that time, sometime between May and August of 2012. I know that there was discussion about whether it's August 2nd or May 30th before bubbles appeared. We heard that suggestion. We've talked with our appraiser, and we're evaluating whether it makes any difference one way or the other. There is some suggestion that because of the economy and the increase that the real estate market since 2008 has slowly but surely gained in value over time, it may be more beneficial to you to have a fair market value in August as opposed to May because of the possible increase in real estate values during that 4-month period. But that's just something that we'll have to evaluate based upon the appraisers looking at comparable sales and that sort of thing. So they'll take measurements. They will they will go walk around with you to inspect the property. They will document any damage that you believe is related to the development of the sinkhole, and they'll photograph that and as I mentioned, document all those damages that you claim. Once that is done, our plan is to, within 30 days of the inspection, so if the first inspection is March 25th, I think is Monday, within 30 days of that, our plan is to have a proposal to the individual homeowner or resident with what we believe to be a fair and reasonable offer based upon an individual evaluation of your claim. And there is, in addition, going back to the form, in addition to property damage, there is a section for you to assert any other types of claims that you believe you have, for example, loss of income from a business that's located in the evacuation area, that sort of thing. So there'll be a location on the form for you to assert any claim that you want us to consider in this resolution process. Once we have made our initial offer to you, then you have a period of time to respond to that. We're hoping that you can respond in 30 days, but there's really nothing set in stone. It's not going to, we won't expect you to respond in 24 hours. We won't expect you to respond in 48 hours. We expect you and hope that you will take our offer. We believe that they will be fair and reasonable. You may not agree with them, but we want you to take your time and make an educated, well-informed decision on whether to accept the offer, whether to reject it and continue the negotiations or the discussions any further, or whether to make a counter proposal to us. If you have a particular valuation in mind that you think your claim is worth, and we're only a few dollars off, or within the range of what you think is the possibility, we certainly want to hear your counter offer. And if once, obviously assuming that we agree on the valuation of your claim and the resolution of your claim, then we will go ahead and document that claim and get you your money. If we can't agree during our discussions on evaluation of your claim, then the next step in the process is for you, if you want to do this, and this is solely within your discretion, if you want to have a third party conduct an informal, non-binding mediation where basically we have an independent third party that we will agree on. There are a number of mediation firms in the Baton Rouge and surrounding areas, New Orleans, where we can agree on a person who is independent, both of you and of the company, to sit down and conduct a negotiation kind of as the middleman so that we can attempt to reach a fair and reasonable resolution of your claim. That's something that you don't have to participate in, but we certainly want to offer that, and we will pay the cost of the mediator. For those of you who are represented by lawyers and who are involved in the federal court litigation, the process that we are going to propose to the liaison counsel appointed by Judge Zaney to conduct the litigation on behalf of the plaintiffs is going to be essentially the same. That process will be a little bit slower because those lawyers may have a different idea of how things ought to work, and we'll have to negotiate that. But they are working diligently towards getting to a point in the federal court litigation, where the process will be the same as that with those of you who have decided not to consult a lawyer, at least at this time, and that those will be parallel processes going on a little bit, not necessarily exactly at the same time, but they will certainly, hopefully, follow the same process, and the resolution of claims hopefully will be the same regardless of whether you're represented by a lawyer or not. So with that, if there are any questions, I will certainly attempt to answer those. Yes?
Okay, you're saying that you have appraisers already in place to go out and appraise our property?
Yes, sir.
Okay, are these appraisers going to take comps from the general area?
They are going to take comps from wherever they can find comps. And let me just tell you this, I'm not an appraiser. We have retained a company called Right Away Services, Inc. They have the appraisers that work there work for both private industry, and they have worked for the state of Louisiana in certain cases. They are professional appraisers. We're going to follow. We're not going to tell them, in other words, we're not going to tell them how to do their work, just like we wouldn't tell your doctor how to treat you. We're not going to tell the appraiser how to do their work, but what we understand is they attempt to find comparables in the same area. If they can't do that, and I understand from our own research that in the last year there's only been about 3 sales within the 3 subdivisions that were evacuated. So I think that they're going to have to go outside of the 3 subdivisions, first to Assumption Parish to see if there are any comparables within Assumption Parish, and then within the surrounding parishes.
Well, I guess my point is, don't you think they need to go out into a fair radius of, say, 50 or 60 or 70 miles? This is a little different situation than they would normally come up against. This property does not flood. You can go elsewhere and find flooded property and put them on stilts. There's not a problem there. But to find property on the ground that does not flood, they're going to have to go a distance.
I assure you they will go wherever they can to find the most comparable property to what they're looking for. I mean, one of the things that they're facing, just from riding through, is finding a comparable neighborhood, for example, where there are manufactured homes next to homes on slabs and slab on grade homes. Next to homes that are worth $200,000 next to homes that are worth $50,000, and I think that's the situation, just based on my observation driving through the neighborhood, that they're going to face. But they will do whatever they can to make sure that the fair market value that they assign to each individual home truly reflects that market value based on all of those factors. Yes.
Heard talk about we're going to give 2.5 to 3 times the appraised value of the property. Is that true?
That is not true. Well, there's not. We are not going to come up with a formula. I think that 2.5 to 3 times value is urban legend, quite frankly, based upon the Bayou, the Grand Bayou buyouts. I have personally talked with the lawyers who were involved in Grand Bayou, and the valuations that were placed on those homes and the resolution of those claims by the companies involved in those was not based upon a formula of 2 or 3 times the value, the fair market value. It may very well be that after they made their calculations and determined what they were going to offer to resolve those claims, people said, well, that's 2 times my value, but there was no formula in Grand Bayou, and we don't intend to have a formula. We're going to do as we promised the local officials. We are going to evaluate each individual claim separately and come up with what we believe is a fair and reasonable valuation. Let me just give you an example where it may benefit our decision not to just say 3 times or 2 times value. It may benefit a particular homeowner. If, for example, somebody does have a manufactured home that's worth, say, $25,000 fair market value, and everybody agrees on that. If we had a formula that says 2 times that value, that of course would be $50,000. It It may be that we, based upon that individual homeowner's circumstances, we decide to offer more than the fair market value. But if we're locked into a formula, we wouldn't be